Is what they've been up to. Again, jury's gone. They'll be back Monday. The new judge in place, Paige Whitaker, she's taken over and is dealing with all kinds of stuff. The court on a lunch break at the moment. But in the morning, they did discuss character evidence surrounding the star witness, Kenneth Lil Woody Copeland, and a firearm at the scene of that 2015 shooting of a YSL gang rival, Donovan Thomas.
The simple fact that he gets the gun from Shannon, or it's Shannon's gun, that he has to shoot back at the opposition gang shows, one, that YSL members, they interchange guns, Your Honor. You're going to see that more evidence is going to come out that we have certain YSL members who may purchase the guns for other YSL members. So this, again, is a part of what the gang does as a part of their enterprise or conspiracy. They pass guns around, so we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr. Stillwell is charged with 2 murders in this indictment, both murders by handguns. So the fact that it comes in that Mr. Copeland got this gun from Shannon is not going to, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear, at least on 2 occasions, that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022, is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value is substantially outweighed by prejudicial value.
This story, which really adds nothing to the state's case, the idea, it's evidence of passing guns around. I mean, they're going to have direct evidence of Quindarius Zachary saying he's a straw purchaser of guns at Arrowhead Pawn. So they don't need that. And gives it to, and has distributed them to people in this courtroom or in this case. But that's exactly what's so prejudicial about this, is they're bringing in propensity evidence that is going to be prejudicial to the issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shamel Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so you're now making a 404B objection also?
Well, it's 404B, but it dovetails into 403 as well. It's just
okay, because it really can't be 404B if it's intrinsic. And you just said you agree it's intrinsic.
Well, no, I agree that the shooting itself, the shooting involving Kenneth Copeland, it seems they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. Mm-hmm. I don't believe that that's intrinsic.
It's not improper character evidence. It's Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense.
So be careful what you admit to when you start making arguments. If you admit something is linked to one of the crimes in issue, don't then try to make an irrelevance argument, because the judge in this case, Judge Whitaker, will slap you down. So Matty Mangino and Katherine Lizardo here. Matt, this is very basic. Is it relevant? Is it, if so, is it more prejudicial than probative? I mean, this analysis is fundamental stuff. First-year law stuff. We're talking about a gun that may or may not have been in the possession of one of the people involved in an ultimate shooting. And the question is the fact that somebody owns a gun, may have had a gun at a different time, is that relevant? And if so, too prejudicial to suggest that, well, then they must have had a gun at the time of the subject crime. I'm going to anoint both of you now. Raise your right hands. You're now officially law and crime judges. So, Matt, what do you think? Would you allow this in or not?
I wouldn't allow it in because, again, I think that the mere fact, that someone has possessed a gun in the past doesn't necessarily is not indicative of someone possessing one during the course of this crime. I mean, I think that, in a sense, at least from my perspective, is a reach that is kind of like a bridge too far. He's possessed the gun in the past, but because he's possessed the gun in the past, we're going to let you argue that he may have or could have or did possess a gun during this specific crime. I think it's a reach.
So, Judge Lizardo, if you agree with Judge Mangino, what would you need to see to let this in? Or maybe you wouldn't let it in. You would let it in anyway. What do you think?
For me, I have a tendency to let it in because this RICO case is so encompassing. It's just so broad that the prosecution was arguing there. We heard that the reason it's relevant is because the gun was being passed around the gang members, and that's what gang members do. I'm paraphrasing what the prosecutor's words were. So in the relevance weighing of evidence, I think it is relevant for the RICO case, but I understand what Matt is saying, that is it a far reach to say that with just a gun? And so as a judge, I would want both parties to come back and give me case law that is more on point on this, or would persuade me more to rule one way or the other. As of right now, just their basic argument is not cutting it for me.
Yeah, it does. It's a great point because RICO is a whole different animal, and who knows how that's going to shake out. Let me ask you this, Matt. We've already gone through 2 judges. We're on number 3 now. We now have an attempt to remove the prosecutors, Love and Hilton. What's your take on that?
Well, they're going to relate that there was an ethical lapse on behalf of the prosecutors in this case as well. I mean, they should have known, and they should have even alerted the judge. Listen, we'd like to talk to you about this, but we need to get defense counsel in here because, these are issues that we can't talk about ex parte. And so, that in some way has, influenced this case. Now you have a new judge, and that's all behind us. But the fact that this did occur, the defense is arguing is enough to disqualify them. They acted unethically in terms of the prosecution of this case, and it just it gets it's kind of it gets absurd. I mean, you want the judge out, the judge is gone now. You want the prosecutor. I mean, where does it end? Yeah. Ultimately, it ends with a new trial.
I'm looking sideways at the bailiff. I don't know who's safe. I don't know who's safe in this case. Katherine, what do you think?
Well, like what Matt said, when is this going to end, or where is, the defense going to stop with their argument? But they're diligently trying to represent their clients, and it is within their right to question the bias and the ethical nature and actions of each of the party. We've seen that in other cases we've covered as well here in Law and Crime and in other states. So the ethical duties of these prosecutors are at question right now, being in that ex parte hearing, because at some point, one or more of them have realized that the defense should be part of this conversation, and they had an ethical duty to raise that question to the judge and bring the defense in. So we will see where this will go, because we just saw how that played out in another case we covered recently.
Yeah, and I keep thinking of the Fondy Willis factor, and of course it is in her jurisdiction there. If you've got the prosecution, top 2 people, if they're kicked out, I mean, is the whole office disqualified then? Do you have to move the case? We don't know where it ends, but right now those issues still are to be decided by this judge. Let's take a break. We'll come back. More Young Thug, and you see the defendants sitting there. I don't know if this is better for them than a day in jail. I don't know.